All right, well, good afternoon, everyone, and welcome to this webinar training titled MAGS 101, the Law Clerk and Court Staff Orientation. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the Maryland State Commission on Criminal Sentencing Policy, which we commonly refer to as the MSCCSP for short. Now, this webinar is primarily intended for court staff and judicial law clerks. The sentencing guidelines play a significant role in supporting fair and proportional sentencing practice. And accordingly, we thank you for participating in this training because court staff and judicial law clerks, you all have an important role in helping to ensure the consistent application and submission of guidelines worksheets. So I do want to note that today's webinar is being recorded, and either this video or a similar webinar video, it will be made available on our MSCCSP website. So if you have a colleague who maybe wasn't able to attend either last week's training or today's training, please let them know that this will be made available on our website so they can view in the future. All right, so before we get started, I just want to go over some general webinar housekeeping. I know we're all very familiar with Zoom at this point, so I do want to note that we are asking participants to remain muted throughout the course of the presentation, just to ensure that we get through it in a timely manner. But that said, we certainly encourage any questions that you all have. If you can submit those questions through the chat box here, my colleague, Sarah Bowles, she is attending this training and will be able to answer any questions that you have. Also in the chat box, you should see a PDF of today's presentation. It'll be uploaded there, so you can feel free to download that, print it out, or save it for future use. All right, so let's move forward to the agenda for today's training. Now, some of you, especially new law clerks who may have just recently onboarded, the concept of the guidelines may be new to you, so I thought it would be helpful to start the presentation by providing some background information about the purpose and goals of the MSCCSP itself. Then I'm going to provide a general overview of the guidelines and discuss guidelines compliance. And then finally, I'm going to wrap up with a live demonstration in our Maryland automated guideline system to show you all how to enter sentence information and submit a worksheet through that system. So let's begin with a brief history of the guidelines and the Sentencing Commission in Maryland. So Maryland was actually one of the first states to initiate a sentencing guideline system. The guidelines were first introduced by the judiciary. In April of 1979, the Sentencing Guidelines Advisory Board, which was formed by the judiciary, approved a system of voluntary guidelines to be piloted in 4 jurisdictions. These sentencing guidelines were then approved for statewide use in the circuit courts starting in 1983. Now, the guidelines in Maryland were in effect statewide for about 15 years with oversight by the judiciary. And then in 1999, the legislature decided that a permanent independent sentencing commission should be created to have oversight over the guidelines. And thus, the MSCCSP was born. Now, the enabling legislation that creates the current day sentencing commission, it outlines a statement of intent for the MSCCSP and Criminal Procedure Article 6-202 that includes 6 goals. First, that sentencing should be fair and proportional, and that sentencing policies should reduce unwarranted disparity, including any racial disparity, and sentences for criminals who have committed similar crimes and have similar criminal histories. Second, that sentencing policies should help citizens to understand how long a criminal will be confined. Third, that sentencing policies should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentences. Fourth, that the sentencing guidelines should be voluntary. Fifth, the priority for the capacity and use of correctional facilities should be the confinement of violent and career criminals. And then finally, that sentencing judges in the state should be able to impose the most appropriate criminal penalties, including corrections options programs for appropriate criminals. Now, the Commission has a few primary responsibilities to help address these goals, with the first responsibility being that we implement and maintain the state's voluntary sentencing guidelines. And this is accomplished through our second major responsibility, which includes the collection and maintenance of an extensive database, which is assembled via the data submitted on the sentencing guidelines worksheets. The Commission uses the guidelines data to monitor circuit court sentencing practice. And we also use the data to examine sentencing patterns and reasons for departure for specific offense categories and within individual cell ranges. And by doing so, we're able to consider adopting changes to the guidelines when necessary. And finally, the Commission is responsible for providing training to criminal justice practitioners to promote the consistent application of the guidelines and accurate completion of the guidelines worksheet. Now, the MSCCSP was created as a balance board of 19 members from all three branches of government. The commission is currently chaired by Judge Brian L. DiLeonardo from the Circuit Court for Carroll County. The membership also includes 3 additional judges, including representatives from each of the 2 trial courts and 1 appellate's court representative who serves as the chief judge's designee. The remaining 15 members include a cross-section of criminal justice officials from the other 2 branches of government, as well as 2 public representatives. Appointed members serve terms of 4 years, and they are eligible for reappointment. Now, the commission makes decisions with respect to the guidelines after deliberating with the many stakeholders that encompass the Maryland criminal justice system, most, if not all, of its constituencies being represented here on the commission. Now, let's get down to the basics here. What is the purpose of sentencing guidelines? The sentencing guidelines are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practices, whereby offenders who are convicted of similar offenses with similar criminal histories, they're treated and sentenced alike. The Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. The sentencing guidelines help achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. The guidelines account for the most common, but certainly not all, characteristics of an offender and his or her crime that are most relevant to the sentencing decision. And they help to provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. So let's discuss some of the basic principles of the guidelines here in Maryland. First, the sentencing guidelines in Maryland are voluntary, so judges may at their discretion depart from the guidelines. The voluntary nature of the guidelines emphasizes that they are designed to be a tool to help inform sentencing decisions and that they are intended to complement rather than replace the judicial decision-making process. The guidelines are also intended to be primarily descriptive. So in other words, the guidelines are informed by analysis of actual sentencing practices and are designed to illustrate to judges how their colleagues are sentencing on average for a typical case. The descriptive nature of the guidelines means that they are not intended to be static, but rather they are dynamic, and the guidelines may be amended when the data indicate that sentences are not consistent with the recommended ranges. And the final basic principle is that the Maryland guidelines are generally limited to cases that originate in the circuit court. Now, before we get into the scope of the guidelines in greater detail here, I'm going to start with a poll question. I have a couple of them scattered throughout this presentation. They really highlight some of the more frequently asked questions that we get from court staff. So I thought it'd be helpful to highlight them in the training here. So I'm going to populate this poll question in a second. It's a true or false. So true or false, Maryland's sentencing guidelines are limited to felonies prosecuted in a circuit court. So I am going to go ahead and launch this poll question here. Just to note, your answer is anonymous. Again, this is just an exercise to highlight some of the more frequently asked questions we get. So I'll give you all just a couple seconds to go ahead and make your selection, and then we'll look at the response. Give you just a couple more seconds here till we get the majority locked in. Okay, so let's go ahead and share the results here. So 20% think that this is true and 80% think that this is false. So let's go ahead and take a look at the answer here. And the answer is false. So the guidelines are not limited to just felonies prosecuted in a circuit court. Let's take a look at the sentencing guidelines scope in greater detail here. So as I just mentioned, the Maryland sentencing guidelines apply to criminal cases that are prosecuted in a circuit court. So the sentencing matters that you see on the left-hand side here, these are scenarios that require a guidelines worksheet. We refer to these as guidelines eligible sentencings. So that's circuit court original sentencings. That includes both misdemeanor and felony offenses, as long as they carry the possibility of incarceration or are being prosecuted in the circuit court as part of an original sentencing, it would be guidelines eligible. It is not just limited to felony offenses. Jury trial prayers and appeals from the district court, they are guidelines eligible only if a pre-sentence investigation is ordered. And in that scenario, a parole and probation investigator would be initiating the worksheet. Sentences adjudicated pursuant to probation before judgments, those are also guidelines eligible. Now, in addition to original sentencings, we also collect worksheets for reconsiderations and modifications, as well as 3-judge panel reviews if they involve a crime of violence as defined under criminal law 14-101. So obviously the more serious offenses, if there is an adjustment made to the original active sentence as a result of that reconsideration, modification, or 3-judge panel review. So just to note, guidelines eligible reconsiderations and modifications, those include sentence adjustments imposed pursuant to Maryland Rule 4-345, a Health General 8-507 order, or again, a 3-judge panel review. Now, the sentencing matters that you see listed on the right-hand side here, these are scenarios that are handled by judges in a circuit court, but they are excluded from guidelines coverage. So jury trial prayers and appeals from the district court, if there's no PSI, offenses that carry no possibility of incarceration, violations of local laws or municipal ordinances, probation violation hearings, criminal non-support and criminal contempt cases, juvenile court adjudications, and then finally, the guidelines do not apply towards district court sentences. So again, these are scenarios that would not require a guidelines worksheet. We do have a chart detailing the scenarios in which a worksheet is or is not required. That is accessible through our main website. So if you think that would be a helpful resource for you to look to, you can certainly download that chart off of our website. Okay, so now that we've discussed the scope in greater detail here, here is another common question that we receive. Let's say the Appellate Court of Maryland has remanded a criminal case back to the respective circuit court for resentencing. Would this scenario require a sentencing guidelines worksheet? I'm going to go ahead and launch this poll here, and I'll read it again while you all make your selections here. So let's say the Appellate Court of Maryland has remanded a criminal case back to the respective circuit court for a resentencing. Would this scenario require a sentencing guidelines worksheet? I'll give you all just a couple seconds until we can get the majority vote here. Okay, so let's go ahead and take a look at the results here. All right, so we have 82% think yes and 18% think no. So let's go ahead and take a look at the answer here. So the answer is no. So just to clarify, a guidelines worksheet is not required if a case was remanded back for a resentencing. So just jumping back to this sentencing scope here. So again, in addition to original sentencings that take place in the circuit court, worksheets are required for reconsiderations and modifications in 3-judge panel reviews involving crimes of violence. So this is different than a resentencing. It would have to be a reconsideration, modification, or 3-judge panel review involving a crime of violence. And in that scenario, a worksheet would be required, but not if a case was remanded back for a resentencing by the appellate court. So hopefully, again, that's a common question that we get. So hopefully that helps to provide some clarification. So another thing that I want to mention is that we have worked with JIS to identify guidelines eligible cases requiring a worksheet in MDEC counties. Now, the majority of all jurisdictions are now utilizing MDEC. So this screenshot that you see here should look pretty familiar to you all. Here's a screenshot of the criminal docket for the Circuit Court for Anne Arundel County from back in June. Now you can see all of the guidelines eligible cases, they have this MAGS yes indicator. indicating that they are guidelines eligible and do require a sentencing guidelines worksheet. So I did want to point out this case indicator. I've gotten feedback from law clerks and court staff over the years who have said that this particular tool has been very helpful to them. I know a lot of them look to these dockets to find out which upcoming cases require a worksheet, so they know that they'll have to go into MAGS, enter the sentence information, and ultimately submit the worksheet for those cases. So if you think that would be helpful to you, please feel free to check out that MAGS indicator on these criminal dockets. Now, I will say we worked very hard with JIS to really fine tune this criteria, so it is very accurate. But it's possible that a case could be identified as MAGS eligible, but just keeping in mind the prior guidelines eligible criteria that we discussed, it's possible that it was flagged in error. So just keep all of that in mind with looking to this indicator. But again, it is very, very accurate. Okay. Now, the Maryland guidelines, they are scored on two key factors, that being the prior record and the seriousness of the offense. And in the Maryland system, an offender score is calculated to account for an offender's prior criminal record. Now, the offender score, it's a summary scale that ranges from 0 to 9, and it measures an offender's criminal history, accounting for 4 factors: the relationship to the criminal justice system when the instant offense occurred, the juvenile delinquency record, the prior adult criminal record, and then prior adult parole and or probation violations. Now, the second component of the sentencing guidelines is the offense seriousness category, represented in Maryland by the offense score. Now, for property and drug offenses, the offense ranking is based solely on the seriousness of the offense. But for person offenses, so those typically involving victims like assault, robbery, as well as weapon-related offenses, the offense score is calculated by considering 3 additional factors, that being victim injury. So 1 point is scored here for a non-permanent injury, 2 points for a permanent injury or death. This can be psychological and or physical injury. Weapon presence, which is the presence of any article or device that reasonably appears capable of causing injury. So 1 point is scored for a weapon other than a firearm, such as a knife or a BB gun. 2 points are scored for a firearm or an explosive. And then finally, special victim vulnerability. So this refers to cases in which the status of the victim tends to render the actions of the offender more serious. So 1 point is scored if the victim's younger than 11 or older than 64, or if they have a physical or mental disability. Now, Maryland has 3 separate sentencing matrices. We have one for property that you see here, one for person offenses that we just discussed, those being the more violent offenses, and one for drug offenses. Now, I just mentioned the guidelines were designed to take both offender and offense characteristics into account. Now, on the left-hand side here, you can see that this represents the offense seriousness category. So each offense in Maryland is ranked based on its seriousness, with 7 being the least serious to 1 being the most serious. And we can see for property offenses, those range from a 7 all the way to a 2. And again, the top row here is the offender score, which is comprised of components of an offender's prior criminal history. So let's just walk through a basic example. Let's say we have an offender who has no prior record. So they have an offender score of 0. And let's say they've been convicted of theft less than 100, which is a seriousness category 7 property offense. Now, looking to the matrix here, we can see that the recommended guidelines range in that scenario would be probation to probation. So again, just a basic example to highlight how the guidelines are calculated, and also to emphasize how important of a role the offense seriousness category plays in the recommended guidelines range. All right, so let's discuss a little bit about how we utilize that data after sentencing to inform policy decisions. So I mentioned this a little bit earlier on in the presentation, but generally speaking, the data are assessed to review sentences and helps to inform the commission whether changes to individual cell ranges or offense seriousness categories are warranted. So for those of you, maybe court staff, administrative assistants, maybe even some law clerks, if you've been working with MAGS for quite some time, you might recall that last summer, actually July 1 of 2022, how we made several changes to the property and drug matrices. A lot of those individual cells were lowered to more accurately reflect how judges were sentencing in those types of cases. So I just wanted to use that example to highlight how important of a role that you all play, as you all are the ones entering that sentence information, submitting these guidelines worksheets to us, because we used all of that data to analyze all of those types of cases and made that sentencing policy decision to lower those individual cell ranges. So again, just reiterating, you all play a very important role in the sentencing policy decisions that we make. Okay, so we also use that data to monitor compliance with the guidelines and to see how often judges depart from the guidelines for specific offenses and offense types. And then finally, we use the data to inform the legislature of sentencing patterns for specific offenses or offense categories. So every year we publish an annual report, details various sentencing trends throughout the state of Maryland. So if that's something that would be of interest to you, please feel free to check out those annual reports on our website. Now, moving towards the discussion towards MAGS. So as you all know, we've developed the Maryland Automated Guidelines System, which we commonly refer to as MAGS, to fully automate guidelines calculation in a web-based application that allows criminal justice practitioners to complete and submit guidelines worksheets electronically. So it is now used in all 24 jurisdictions. And I just want to quickly highlight the two primary purposes that the sentencing worksheet itself serves. So the first purpose of the worksheet is to inform the judge of the guidelines prior to sentencing. So Criminal Procedure Article 6-216, it indicates that the court shall consider the guidelines at sentencing. And in order to do so, a sentencing guidelines worksheet must be prepared. The second purpose of the worksheet is to provide data so the commission can make informed decisions about sentencing policy. So Criminal Procedure Article 6-210 requires that the commission collect sentencing guidelines worksheets, automate that information, and monitor sentencing practice. All right, so now that we've discussed a little bit about the background and goals of the MSCCSP, we're going to move on and talk a little bit more about how the guidelines themselves are calculated. Now, I know that generally it's state's attorneys, parole and probation investigators who are initiating the guidelines worksheet, but I do want to discuss the definitions of single versus multiple criminal events because that does factor into the overall guidelines calculation itself. But I think understanding a single versus a multiple criminal event will help you all too to provide some clarification about how the guidelines themselves are calculated. So I'm going to begin by defining a single criminal event, which for guidelines purposes is defined as one or more crimes committed in the course of the same transaction. Now, I do want to note this language that you see noted in red, it became effective February 1 and states that in determining whether multiple crimes are committed in the course of the same transaction, the person filling out the guidelines worksheet shall consider whether the crimes are 1, are committed in close in time and an uninterrupted course of conduct, 2, occur in the same location, and 3, are similar in nature or intertwined, for example, whether they share a common scheme or purpose. Now, multiple criminal events means that more than one criminal transaction was committed over a period of time. Multiple criminal events being sentenced together, they may have occurred on the same date or different dates. But generally, offenses that occur on different dates are almost always considered separate criminal events. Now, a sentencing event is defined as a sentencing disposition or hearing for an individual defendant conducted in front of one judge on the same day. So when you have multiple criminal events, they often have different offense date, different case numbers. If they are sentenced by the same judge on the same day, that means that they constitute one sentencing event, meaning one set of sentencing guidelines should be completed for each sentencing event. And we're going to take a look at what that should look like in a moment here. Before we do, I also just want to note that merged or null prost offenses should not be included on the worksheet. So ideally, state's attorneys should be deleting any merged or null prost offenses prior to you getting into MAGS and going to enter sentence information. If they don't, we can talk about how to delete those from MAGS when we get to the MAGS demonstration. All right, so let's take an example. Let's look at an example here of a sentencing event that includes two separate criminal events. And I know the text is a little small, so just bear with me here. In this upper left-hand corner, you can see we have a distribution of PCP that occurred on 7/10 of 2021, has its own unique case number ending in 4001. Now, in the bottom right-hand corner, we have an assault first degree that occurred a couple of months later in January of 2022. Again, has its own unique case number ending in 8001. Now, by guidelines rule, each separate criminal event should correspond to their own guidelines worksheet. So in this case, even though we have one convicted offense per criminal event, it's still correct that they're being populated on two different worksheets. You have an individual guidelines range calculated for each of those convicted offenses, but there is still one overall guidelines range calculated between them, given that they are being sentenced as part of the same sentencing event. So again, we're going to talk a little bit more about this when I get to the MAGS demonstration, but when you do have multiple criminal events being sentenced as part of one sentencing event, this is an example of how it should look when you're viewing those worksheets in MAGS. All right, so next we're going to review how to determine if a sentence is a guidelines compliant sentence. Now, a sentence is deemed compliant with the guidelines if the guidelines applicable sentence, which is the sum of incarceration, credited time, and home detention time, if that falls within the applicable guidelines range. So important to note, generally suspended time is not considered when determining if a sentence is compliant. There's one exception to that general rule involving corrections options, which we'll look at a little bit later on. But again, it's really the sum of incarceration, credited time, and home detention time that's used to determine compliance with the guidelines range. I also just want to note that compliance is calculated by comparing the overall sentence across all convicted offenses in a sentencing event to the overall guidelines range for that sentencing event. So, for example, it's possible that the sentence imposed could exceed the upper guidelines limit for one offense in the sentencing event, fall below the lower guidelines limit for a second offense, but that overall sentence, when adding together the sentence for both counts, taking into the consideration whether they're concurrent or consecutive sentences, they could still fall within that overall guidelines range for the sentencing event. Now, there are a few qualifiers to consider regarding guidelines compliance, and that is effective April 1 of 2021, sentences adjudicated pursuant to an MSCCSP binding plea agreement are deemed guidelines compliant. So again, if some of you have been working with the guidelines for quite some time, you might remember the former ABA plea agreement, but it's important to note that former ABA plea agreement, it has been replaced with MSCCSP binding plea agreement. And the criteria for what constitutes a guidelines compliant MSCCSP binding plea has also been revised. And we'll look at that in the next slide. Also, just want to note that the MSCCSP binding plea compliance rule, it does follow the same logic as that former ABA plea agreement compliance rule, which was initiated based on feedback received from the judiciary that binding pleas represent a consensus of the parties in the court within their specific community. And accordingly, the commission felt it was important to define these as compliant sentences. Now, binding pleas, they are three-party agreements in which the defense and the state present to the court on the record an agreement that incorporates a specific sentence. And if the judge accepts that agreement, it becomes binding on the court pursuant to Maryland Rule 4-243 subsection C. Now, following a review of binding pleas in 2020, the commission ultimately agreed that that former term ABA plea agreement, it wasn't universally known and should be replaced with the more intuitive MSCCSP binding plea agreement. Further, effective April 1 of 2021, the MSCCSP narrowed the definition of what constitutes a guidelines compliant plea and adopted language to specify that an MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, and not merely a sentence cap or range. So in totality, the definition of an MSCCSP binding plea is a plea agreement presented to the court, an agreement by an attorney for the government and the defendant's attorney, or the defendant when proceeding pro se, that a court has approved relating to a particular sentence and disposition. An MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, and not merely a sentence cap or range. The court has the discretion to accept or reject the plea, and the agreement is binding on the court under Maryland Rule 4-243, subsection C, if the court accepts the plea. So I know that was probably a lot of information to take in and digest. So let's take that information and let's look at some hypothetical sentencing scenarios here. So let's say the guidelines for the sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? So I'm going to go ahead and launch this poll. And I'm going to review the question again as you all start making selections here. So let's say the guidelines for the sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? Give you all just a couple more seconds so we can get a majority vote here. Okay, so let's go ahead and take a look here. So we have 35% thinking yes and 65% think no. So let's go ahead and look at the answer here. So the answer is no. As a reminder, an MSCCSP binding plea, it must involve an agreement to a specific amount of active time, if any, and not merely a sentence range or cap. So in this scenario, the court accepted a plea agreement to a sentence range anywhere from probation to 2 years. And this is why it would not constitute an MSCCSP binding plea agreement. So let's look at another example here. Let's say the guidelines for the sentencing event are 1 year to 6 years. The state and the defense present to the court a plea agreement to 5 years, all suspended with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended with credit for 62 days. Is this an MSCCSP binding plea agreement? I'm going to go ahead and launch that poll. All right, I'm going to read through it one more time as you all start making selections. So let's say the guidelines for the sentencing event are 1 year to 6 years. The state and the defense present to the court a plea agreement to 5 years, all suspended with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended with credit for 62 days. Is this an MSCCSP binding plea agreement? Give you all just a couple seconds here to lock in your answer. All right, let's go ahead and share the results here. All right, so we have 88% thinking yes and 12% think no. So let's go ahead and take a look at the answer here. So yes, this scenario would constitute an MSCCSP binding plea agreement because there was an agreement to a specific amount of active time, that being 0, or in other words, no post-sentence incarceration. Therefore, this would constitute an MSCCSP binding plea agreement. So I hope going through those two different scenarios, I hope that did help to provide some clarification. If you ever have a question, you can feel free to call us. If there's also a question as to whether a sentence was adjudicated via an MSCCSP binding plea agreement, we certainly encourage you to discuss that with the sentencing judge. The state's attorney, I'm sure, could also provide some information regarding the terms of the plea agreement. All right, let's look at one more scenario. This isn't a poll question, just another scenario that I want to highlight here. So let's say the guidelines for the sentencing event are 1 year to 5 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from 2 years to 4 years. The court accepts this agreement and imposes a sentence of 5 years, suspend all but 2 years. Now, while this agreement is not an MSCCSP binding plea agreement, right, since it involves an agreement to a sentence range, it wouldn't constitute an MSCCSP binding plea agreement, but the sentence itself is still guidelines compliant, since that guidelines applicable sentence of 2 years falls within that overall guidelines range of 1 year to 5 years. So just want to highlight this scenario to show that you can definitely have a guidelines compliant sentence that is not adjudicated pursuant to an MSCCSP binding plea agreement. So moving forward, an additional qualifier to consider is the role of corrections options. Now, sentences to corrections options programs, we're going to look at the whole list in a second here, but those involve drug courts, residential substance abuse treatment, home detention. They are deemed compliant provided that the initial sentence plus any suspended sentence. So essentially, as long as the total sentence falls within or above the applicable guidelines range, and the case does not include a crime of violence, child sex abuse, or escape. So this is the one exception I mentioned earlier in which suspended time is considered in determining a guidelines compliant sentence. Now, corrections options, they allow judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the sentencing guidelines. So corrections options include home detention, inpatient residential treatment, inpatient drug or alcohol counseling under Health General 8-505 or 507 order, drug court, participation in any problem-solving court, a sentence with required substance abuse treatment for the possession of controlled dangerous substances, work release, and or weekend or other discontinuous incarceration. So it's important when we get to the MAGS demonstration. I'm sure many of you are already familiar with the Alternatives to Incarceration tab that lists all of these corrections options programs, but it's important that these are being marked correctly in MAGS as it does factor into guidelines compliance if one of these programs was in fact utilized. All right, so let's look at a poll question here. Let's say the overall guidelines range for the sentencing event is 1 year to 3 years. The defendant was sentenced to a 6-year total sentence, all of which is suspended. The defendant was also sentenced to drug court, a corrections option program as defined under commission criteria. Which of the following best describes the sentence imposed? Is this a departure below, a departure above, or a guidelines compliant sentence? Go ahead and launch this poll question here, and I'll read through it one more time. So let's say the overall guidelines range for the sentencing event is 1 year to 3 years. The defendant was sentenced to a 6-year total sentence, all of which is suspended. The defendant was also sentenced to drug court, a corrections option program as defined under commission criteria. Which of the following best describes the sentence imposed? A departure below, a departure above, or a guidelines compliant sentence? About 5 more seconds here. All right, let's go ahead and end this and we'll share the results. All right, so this is interesting. We're pretty split. We have 25% thinking this is a departure below the guidelines, 33% think a departure above, and 42% think it's a guidelines compliant sentence. So let's go ahead and take a look at the answer here. Now, this is a guidelines compliant sentence. So as previously noted, sentences to corrections options programs are compliant provided that the initial sentence plus any suspended sentence is falling within or above the applicable guidelines range, and the case doesn't include a crime of violence, child sex abuse, or escape. So in this case, that 6-year total sentence is falling within or above the overall guidelines range of 1 year to 3 years, and the defendant was sentenced to a corrections option program, that being drug court. So this is why it would be a guidelines compliant sentence. All right, so that wraps up our hypothetical sentencing scenarios. Hopefully you all found those to be helpful exercises. I'm just going to wrap up with one more slide to consider regarding guidelines compliant, and that is that sentences in which the offender received credit for time served with no post-sentence incarceration time, and if that amount of credited time exceeds the guidelines range, it is deemed guidelines compliant. So for example, if the guidelines range is probation to 3 months and the sentence is 6 months fully suspended with credit for 100 days, the sentence would still be deemed guidelines compliant, even though that credited time exceeds the upper guidelines limit. All right, so next we're going to be moving towards our MAGS demonstration. I just want to quickly highlight our guidelines calculator tool before we get there. Now, our guidelines calculator tool can be accessed via our main website here by clicking the GLCT icon. The guidelines calculator tool is a standalone tool that can be utilized by anyone to calculate sample guidelines. So if you're familiar with MAGS, you can see that these first three tabs here, they essentially mirror MAGS. The only difference is you don't need a user ID, you don't need a password to utilize the guidelines calculator tool. The only caveat is that it doesn't save any information that you enter like MAGS does. So once you utilize the tool, you want to make sure you're saving a PDF or printing it out for future use. But I just wanted to highlight this tool because it's very possible many of you may go on to becoming prosecutors or defense attorneys, and this would be a particularly helpful tool to keep in mind once you do get to the point where you're prosecuting or defending cases in the circuit court. I know it's a very helpful tool. I've gotten a lot of positive feedback from both state's attorneys and defense attorneys who utilize it while calculating sample guidelines. So I did just want to point that out. And before we actually log into MAGS, I want to quickly highlight this screenshot of our MAGS homepage, which is www.msccsp.org/MAGS. So this is where you could actually access MAGS by clicking this MAGS login button. But also on this homepage, we have several instructional and support materials for you. So we have a MAGS user manual, very detailed, lots of screenshots. So if you have a question about MAGS, you'll probably find the answer in that user manual. We also have instructional videos. If you click on that link, you'll see two. The first video is geared towards parole and probation agents and state's attorneys, and it walks you through how to initiate a sentencing guidelines worksheet in MAGS. The second video is geared towards court staff and law clerks, judges, and focuses on entering sentence information and submitting worksheets through the system. Very similar to what I'm going to be showing you in a moment here. So again, just pointing those out. If you have a new colleague who comes on board, or if you ever want a refresher, you can certainly check out those instructional videos. Okay, so I'm going to go ahead and bring up MAGS. If you can just bear with me one moment here. Okay, so you should be seeing the MAGS login screen now. So to start, many of you have probably already tried logging into MAGS. I know that there are some law clerks who may have just recently onboarded and haven't yet logged into MAGS. So just to highlight, everyone's user ID, it starts with a prefix that corresponds to their individual agency or jurisdiction. So for the majority of you being court staff and law clerks, your prefix is going to be courts / followed by your first name, period, last name, and then whatever your current work computer password is. Now, the exception to that is Prince George's County law clerks and court staff. You all would be logging in with a 16 court / prefix, followed by your county username as well as your county password. If those of you who may not have tested your MAGS access yet, I do want to note that you have to get access granted by JIS. I'm sure a form was probably filled out if you're a newer law clerk, asking permission for other various JIS systems. On that same form is a request for MAGS access. So if that wasn't initially checked when the form was submitted to JIS, that could be a reason why you're having login issues. But if there's ever a question, if you think you're supposed to have access and you can't figure out why you can't log in, just feel free to contact our office and we can look into that. I'm going to go ahead and log in with my user ID and password here. Okay. So after logging in, you're going to be brought to our home screen here. From the home screen, users can either create a new worksheet or you can view, edit, or delete an existing one. Now, law clerks and court staff, you all are going to be searching the system for previously initiated cases. So you can then go in and enter sentence information and ultimately submit those worksheets. So there are a couple of different ways you can search. You can filter entirely by jurisdiction. You can enter the defendant's state identification number, the first name, last name, or case number associated with the defendant, or the worksheet ID, which we'll talk about in a moment here. So I already went ahead and initiated some sample test case here. So I'm going to filter by Prince George's. I'm going to enter my defendant name, which is John Smith here. And you can see once I do that, I see two case numbers displaying here, one ending in 1122 and one ending in 1133. Now, we talked earlier about how when you have multiple criminal events sentenced in front of the same judge on the same day, how they constitute one sentencing event. Now, if that is the case, when the worksheet preparer goes to initiate this worksheet in MAGS, they should be initiating all of those multiple criminal events. So all of those unique and different case numbers, they should all be initiated under one MAGS record. And if initiated properly, they would share the same worksheet ID. So I can see, even though I have two different case numbers, they share this worksheet ID number of 145675. That's how I know that they were a part of the same sentencing event and initiated accurately. Now, many of you have probably run into the issue where perhaps the state's attorney or parole and probation agent actually initiated this worksheets separately as separate MAGS records, even though they were a part of the same sentencing event. If that were the case, when you go to search the home screen here, if you see two different worksheet ID numbers, even though you know that they're a part of the same sentencing event, it's going to create a problem. You're going to be able to successfully submit the worksheet for the first case, but when you go to submit the worksheet for the second case, you're going to get a duplicate error message. It's going to say a worksheet's already been submitted. That includes the same SID number, date of birth, and date of sentence as a worksheet that had already been submitted. So at that point, you need to reach out to our staff. We can combine it for you behind the scenes and then send you back a revised PDF. But it's good to get ahead of that. If you do notice that multiple criminal events, they should be combined, but they were instead initiated separately, we encourage you to reach out to the state's attorney or parole and probation agent and ask them to combine those cases for you under one MAGS record before you even proceed with entering that sentence information and submit the worksheet. One, it's less work for you because that way you know it's been combined from the get-go. You won't have any issue when you go to submit the sentence information. Two, it's good for the state's attorney and parole and probation agent to be reminded that they need to combine these under one worksheet ID to ensure a proper overall guidelines range is being presented to the judge at sentencing. But again, if you run into issues, if you get that duplicate error message, just reach out to our staff and we can help you resolve that issue. Okay, so let's say here, I searched for my John Smith case. So we're going to go and proceed with entering sentence information. We have a couple of icons here. Obviously, the little pencil icon is your edit icon. Your delete icon is the trash can icon, and the Adobe icon is where you can view the worksheet. One last thing I want to mention before we proceed with entering sentence information. We talked earlier about how merged or null prost offenses should be deleted from the guidelines worksheet. So let's just say in this example, this case number ending in 1133, let's say it involved a theft-related offense that ended up being null prost at sentencing. If these are combined under the same worksheet ID and share that same worksheet ID, you would not want to click the delete icon next to the 1133 from the home screen here. If you do that, it's going to delete the entire worksheet ID and every case number that's associated with that worksheet ID. So it's the list of offenses tab is where you would want to delete that information. I'm going to show you how to do that in a second. I just wanted to mention that while I was still on the home screen. All right, so I'm going to go ahead and click on this delete icon here. Now, whether you're initiating a brand new worksheet or if you're editing a previously initiated worksheet, you're always going to be brought to this offender information tab first. So you can see we have MAGS divided into 8 screens, each of which represents a different section on the guidelines worksheet. So generally, it's offender information, offender score, list of offenses, and most of the victim information tab, that should be completed prior to sentencing. So all of that should be completed prior to you all taking over and entering sentence information. I'm just going to quickly show you what each tab looks like, because it's possible you may need to make minor changes to those tabs before moving forward and ultimately submitting the worksheet. So offender information, self-explanatory. This is where we're capturing basic information about the worksheet preparer and the defendant. A common error, it's possible that the defendant's name was entered wrong. If you notice that prior to submitting the worksheet, you can simply make that change on this tab here and then just make sure you click Save this page after any changes. Moving forward to offender score. This is where we're capturing basic components of an offender's prior criminal history. Again, should be calculated by the state or parole and probation prior to sentencing. That said, it's possible, especially with regards to the prior adult criminal record score, if the defense comes up with a different calculation than the state and it's brought to the judge at sentencing, ultimately it's the judge who will make the decision as to the number of points that should be scored for the prior adult criminal record. So if the judge decides that it should be scored differently than how the state had originally entered it into MAGS here, again, ideally the state's going back and making that change prior to you going in and entering sentence information. I know sometimes that isn't able to happen in a timely manner. So it's really a quick fix on your end. Like, for example, if this was initially calculated to be a moderate record, but the judge ultimately decided it should be minor, you would just click the appropriate radio button and then click save this page here. Also, just want to note that if that were to happen, any changes to the offender score, MAGS would automatically update the overall guidelines range when that kind of change is made. So that's not something that you have to worry about. All right, moving on to list of offenses. So this is where all of the convicted offense information is entered. And again, I know I sound like a broken record with this multiple criminal event, single sentencing event scenario, but it's just important to keep in mind. Again, when you have those multiple criminal events in a single sentencing event, you should see all of these case numbers displayed on the same list of offenses tab, as well as the sentence tab here. You shouldn't have to go back to the home screen and look up each case number individually. If they were initiated properly, and as long as they are a part of the same sentencing event, you should see all of those unique case numbers listed here. And then victim information. Well, let me go ahead. I'm going to quickly actually click on the edit icon. So this brings you to the offense offender score screen. Again, this is all completed prior to sentencing, but similar to the offender information, if there were any discrepancy between the offense score calculation and the judge decided that, for example, the points for victim injury or weapon presence should be different than what is reflected in the system, you would just select the appropriate radio button and then click save this page and close out. And then victim information here, this is the last tab that should mostly be completed by the state and parole and probation prior to sentencing. Throughout MAGS, you will see these question mark icons. If you click on this icon, it gives you more detailed explanations of what we're trying to capture in each field. So all of this information is taken directly from our manual. So really, if you ever have a question about what we're trying to capture, please utilize these question mark icons. I guarantee you will find them helpful. So with regards to victim information, the state should be entering the information for the first couple fields here. That said, not all of these fields can be completed prior to sentencing. So for example, whether the victim was present at sentencing, if they gave a written or oral victim impact statement, we ask you to complete that information since that can't be completed until after sentencing. So I'm just going to go ahead and make my selections here while I'm on this tab, and then I would click save this page here. Okay, so that's really the first tab that you're going to start entering sentence information or entering information period for. Real quick, I'm going to jump back to this list of offenses tab. I mentioned earlier that merged or null prost offenses should be removed from guidelines calculation. So let's say this felony theft offense that was associated with the 1133, let's say that that offense ended up being merged or null prost at sentencing. So I want to remove it from the worksheet. To do that, I would simply click on this trash can icon next to the offense. It's going to ask me to confirm I want to delete it. And I would simply click OK. And then I would click save this page. Again, if you delete an offense, if deleting that offense happened to alter the overall guidelines range here, MAGS would automatically recalculate it for you. That doesn't tend to happen. The lesser offenses are the ones that tend to be merged or null prost. So normally the overall guidelines range doesn't change, but if it were, MAGS would automatically do that for you. So that's not anything you have to worry about. So then you would click save this page and then proceed to the sentence tab here. So you can see the sentence tab, it pretty much mirrors what you see on the list of offenses tab. You see each convicted offense listed separately. And then you would just proceed by entering the edit icon next to the first offense here. So once I do that, you can see I get the offense sentence screen. Now, mandatory fields in MAGS, they're marked by these red asterisks, meaning that you have to enter some sort of value in those fields before you can move forward and ultimately submit the worksheet. So based on what you enter for the total sentence, suspended time, credit for time served, and home detention, because we can see those are mandatory fields, MAGS will automatically calculate the jail prison for you, as well as the guidelines applicable sentence. So I'm going to start by entering a sentence for this assault first degree. I'm going to enter 20 years, suspend all but 1 year with credit for 30 days. So I'm going to begin by entering this total sentence of 20 years. And then I'm going to enter 19 years in the suspended field because the sentence imposed was 20, suspend all but 1 with credit for 30 days, which means 19 years is being suspended here. So jumping down to credit for time served, if you know the calculated, the days calculated, you can just go ahead and enter that number here. I know in some jurisdictions, it may say on the docket information, sentence to commence as of, and then it'll give you a date that actually precedes the sentence date that occurred. And what you would want to do is basically plug in those two dates, whatever that sentence start date is, and the end date would be whatever that sentence hearing date is. Once you have those dates plugged in, you would click calculate days, and MAGS will automatically calculate those days for you. And then you just have to click save. So I did just want to point out that we have that tool available to you. And then home detention, I'm going to enter 0. So you can see based on what I entered here, I have 11 months of jail prison moving forward because that's the 1 year minus the 30 days credit for time served. So that gives me 11 months of jail prison moving forward. And then I have a guidelines applicable sentence of 1 year. So just a reminder, the guidelines applicable sentence is the sum of credit for time served, home detention, and jail prison time. That's what's generally used to determine compliance. So I get that 1 year by adding the 30 days credit with the 0 home detention and the 11 months of jail prison. So that's just kind of a way that you can check your math too. If you know what that sum of credit, home detention, and jail prison should be. So moving over to subsequent offender proven, if the defendant was convicted as a subsequent offender, you would mark that here. If any restitution was proven, let's go ahead and mark yes. I know oftentimes restitution hearings, they take place at a later date. So if you know that restitution will be ordered, but you don't happen to know the amount at the time you're entering this information, you would just say yes here, and then you could simply check unknown amount next to the actual amount of loss. Then moving on to the upper right-hand corner. So this question asking, is the sentence for this offense consecutive to another count in the sentencing event? So you have to mark yes or no in response to that question. So if this sentence is running consecutively to another count within this sentencing event, so not outside of this sentencing event, perhaps if a sentence was imposed and the judge stated that it needs to run consecutive to an entirely different case that wasn't being heard that same day, that means it's running consecutively to something outside of the sentencing event. If it's running consecutive to another count within the sentencing event, you would want to mark yes. And then MAGS is just reminding you that you would need to flag at least 2 counts as running consecutive in order for the sentence to be summed to obtain the total sentence length for the case. Now, if the sentences are running concurrently to one another, or if there's only one convicted offense in the sentencing event, you want to mark no in response to this question. And then whether a probation before judgment was granted in the case here. All right, so I'm going to go ahead and save this page and close. So you can see once I successfully save sentence information, there's a little check mark under the entered column. That's how you know that you've successfully saved that information. All right, so we have information entered for the assault first degree. I'm going to quickly go in and enter information for the burglary first degree. So let's say the sentence imposed for this offense was 10 years, suspend all but that 30 days of credit for time served. I want to show you all a little trick. Some of you may already be familiar with it, but for those of you who are new, I think you would find this helpful. So when you have a sentence that's imposed, like a total sentence, suspend all but credit for time served, you would want to begin by entering the total sentence, which in this case is 10 years. You would leave suspended blank for a moment, and then you would jump down to the credit for time served, which in this case is 30 days. And then you would plug in 0 for home detention. And then whatever you see populating in the jail prison field, which is 9 years and 11 months here, that's what you want to plug into the suspended field. And by doing that, you're going to zero out the jail prison field. And then I have a guidelines applicable sentence of 0.0833, which is essentially just that 30 days of credit for time served. Now, one thing to note, when you're entering credit for time served, if credit for time served was just, awarded generally in one case, you can apply that credit for time served for each convicted offense if those sentences are all running concurrently to one another. When sentences are running consecutively to one another, you'll only want to enter that credit for time served in for one of those offenses. Otherwise, if you enter it in for all of the offenses that are flagged as running consecutively, MAGS is going to add that credit for time served across all offenses that are flagged as consecutive. So in this case, if they were running consecutively and I entered this credit, it would actually reflect 60 days of credit as opposed to 30, and we don't want that. But again, as long as sentences are running concurrently, you can reflect that credit in for all of those convicted offenses. And then I'm just going to make my selections here. Now, these sentences are running concurrently, so I'm going to mark no in response to this question, and there was no PBJ. I'm going to click Save this page and close here. All right, so I have my individual sentence information completed, which means I'm going to move forward to the GLS overall sentence tab. Now, on the left-hand side, you can see that MAGS will calculate the total overall sentence across all the convicted offenses. So it'll factor in whether sentences are running concurrent or consecutively. So in this case, I have a 20-year overall sentence with 19 years suspended, 30 days credit with 11 months of jail prison moving forward, which gives me a total guidelines applicable sentence of 1 year, right? Because that's the sum of incarceration, credit, and home detention. So just comparing it to this overall guidelines range of 4.25 years to 12 years, I can see that as of now, it looks like it's going to be a below departure from the guidelines. You would then just move forward with entering the remaining sentence information. So that being the date of sentence. All right, so disposition type here. I'm gonna, pull this up here. I'm gonna quickly run through the different disposition types because this is one field that it's very important to make sure that you're marking these disposition types accurately. As we know, like MSCCSP binding plea agreements, that factors into guidelines compliance. So we really want to make sure we're selecting these appropriately. So as a reminder, an MSCCSP binding plea agreement, there has to be a three-party agreement to a specific amount of active time, if any, and not merely a sentence cap or range. And the judge needs to accept that plea, in which case it would become binding on the court. Now, an other plea agreement means that a disposition resulted from a plea agreement reached by the parties that did not include an agreement to a specific amount of active time, if any, and or the agreement was not approved by and thus not binding on the court. A plea no agreement is when the defendant pled guilty without any agreement from the prosecutor or judge to perform in a particular way. Bench or court trial, the disposition resulted from a trial without a jury in which the judge decided the factual questions. And then jury trial is when the disposition resulted from a trial in which the jury decided the factual questions. So if you ever have a question about which disposition type to reflect, as I mentioned earlier, definitely consult with the sentencing judge and or state's attorney. I'm sure they'll be able to help you make sure that you're accurately reflecting the disposition type. So in this case, I'm going to go ahead and mark that this was an other plea agreement. So jumping down to this question, it's asking, is this sentencing event the original sentencing event or a modification to a crime of violence? Now, this field will only become enabled if the sentencing event involves a crime of violence, which I had an assault first degree, which is considered a crime of violence under criminal law 14-101, which is why this field is becoming enabled. So if you're entering information for an original sentencing event involving a crime of violence, you would just simply select original sentencing event here. If you're entering information as a result of a modification or a reconsideration that involved a crime of violence, you would mark modification to crime of violence. And then the field below it is going to ask you to indicate what type of modification this was. So whether it took place pursuant to Maryland Rule 4-345, whether the modification was as a result of a Health General 8-507 order, or a 3-judge panel review. So I'm going to go ahead and just change this back to original sentencing here, in which case that becomes disabled. So you then go on and enter the length of probation imposed. Now, 50% of sentence announced, this is referring to statutorily when a sentence of confinement that is to be served is imposed for a violent crime as defined in Correctional Services 7-101. The court shall state in open court the minimum time the defendant must serve before becoming eligible for parole. So statutorily, if the defendant was sentenced to some sentence of confinement for violent crimes under Correctional Services 7-101, those include all of the crimes of violence defined under Criminal Law 14-101, as well as burglary first, second, or third degree. So if a sentence of confinement is imposed for any of those types of offenses, this field will become enabled. And statutorily, the judge should be making an announcement as to the minimum time the defendant must serve before becoming eligible for parole. So in this case, this involves an assault first degree. So it would become enabled and mandatory, which means I'm going to mark yes in response to that question. And then jumping down to victim court costs, I know I'm throwing a lot of information at you all, but I'm just using this as an opportunity to kind of highlight what we're capturing in these fields here. So again, victim court costs, statutorily, the judge should be imposing a $45 circuit court fee for all crime types. That even includes drug offenses. A $45 circuit court fee should be being imposed outside of any additional court costs and fines. So this field is asking you to confirm whether or not the judge did impose that $45 circuit court fee. So ideally, you should be marking yes in response to this question. This is asking if the judge ordered a no contact with the victim, and then whether the judge made a written request for a parole notification. You don't need to worry about this reconsideration field. Jumping down to additional information, this is where any additional information that the judge would want reflected on the worksheet, that's where you can enter the information here. And then you would click Save this page. All right, so moving on to alternatives to incarceration here. This is where we're capturing whether the offender was sentenced to a corrections option program or to some other alternative to incarceration. So again, you want to make sure you're reflecting these programs accurately, since sentences to corrections options do factor into guidelines compliance. So I'm going to first mark no in response to this question, and then I'm going to go back and show you how MAGS changes depending on the selections that you make. So I'm going to mark no in response to corrections options, but I'm going to mark that yes, the defendant was sentenced to some other alternative to incarceration, that being outpatient substance abuse treatment, and then other, let's say the defendant, was ordered to complete anger management. And let's say he was ordered to complete 100 hours of community service with a $250 criminal fine. I'm going to go ahead and save that page. All right, so going to the departure and submit tab. MAGS will automatically calculate whether there is a departure from the guidelines. So as I just mentioned here, the GLS overall sentence tab, the 1 year overall guidelines applicable sentence is falling below the overall guidelines range of 4.25 years to 12 years. So this is why MAGS is automatically flagging this as yes, this is a departure from the guidelines. Now, when there is a departure, you'll see there's space for 3 departure codes. It isn't necessary to enter 3 different departure codes, but if there are multiple reasons for the departure, they can be reflected here. So when you click on the dropdown, depending on whether it's a departure below or above the guidelines, you'll be presented with a list of the most common reasons for the departure, that being whether it's aggravating or mitigating reasons here. So we can say here that perhaps number 1, a plea agreement was reached for a reduced sentence. If none of these common reasons for departure match the circumstances for the departure in the case, you can always select other circumstances and then provide the reason for the departure. This should be coming from the judge. So you should be confirming with the sentencing judge which departure code to reflect on the guidelines worksheet. So in this case, let's just say that the defendant is the primary caregiver for his family. And that was one of the reasons for a below departure from the guidelines. And then you would simply click Save this page. Now, prior to actually checking this box and submitting the worksheet through MAGS, I always recommend clicking this View Worksheet PDF button first, just to review the worksheet. You can take it to the judge, review all of the sentencing information that you entered, just to make sure everything's accurate. That way, if an error is detected, you can still go back and make that change before ultimately submitting the worksheet. But if you submit the worksheet, notice after the fact that there was an error, don't panic. You can feel free to reach out to our office. We can make that change to the submitted worksheet. We're the only ones who have the capability of editing submitted worksheets. So we can make that change and send you back a revised PDF for the judge to sign. So here is what the completed PDF would look like. Again, multiple criminal events, they display on 2 separate worksheets. That's a common question I get. People are, they call and they wonder why like a second case number is missing entirely from the worksheet, but it's probably because it's being considered a second criminal event. And if you were to scroll, you would see it displayed on its own worksheet here. So this is the worksheet that you would typically print off, have the judge sign, and then upload to MDEC, most likely. Now, I do want to show you quickly those other qualifiers that to consider regarding guidelines compliance, how MAGS accounts for those in the system here. Okay, so we already talked about, we know that this sentence as entered is the departure from the guidelines. However, any sentence adjudicated pursuant to an MSCCSP binding plea agreement, it's automatically going to be deemed guidelines compliant. So if I were to go back and change this to MSCCSP binding plea agreement, and then go back to the departure and submit, you can see that MAGS is now saying, no, this isn't a departure because it was adjudicated pursuant to an MSCCSP binding plea agreement. So sometimes I get questions where people are anticipating a departure and they don't understand why MAGS is not flagging it as a departure. So this could be why. Just pay attention to the red text that you see, because it's probably telling you why there is not a departure from the guidelines. Now, also want to show you real quick how MAGS accounts for corrections options. So if I were to go ahead, we talked about how the corrections options, it can't involve a crime of violence. So I'm going to go ahead and delete this assault first degree from the list of offenses tab. And then I'm going to jump back to the alternatives to incarceration. And let's say that drug court was imposed for this case here. Oh, I need to go back and change this. Okay, and then if I go back to the sentence, and let's make this a fully suspended sentence. So let's say this is 10 years, fully suspended. No credit. Okay, so looking here, I can see that this guidelines applicable sentence of 0, it looks like it's falling below this overall guidelines of 3 months to 3 years. However, the defendant was sentenced to drug court here. So if I were to go to this departure and submit tab, I can see that actually it's not a departure. 1, because it was adjudicated via an MSCCSP binding plea agreement, and 2, because it was adjudicated, or I'm sorry, because it involved a corrections option program. So again, these could all be reasons why you're thinking there might be a departure, but ultimately there is not a departure from the guidelines. And then ultimately you would just check this box and submit the worksheet. Okay, so that concludes the MAGS demonstration. I'm just going to wrap up with just 1 or 2 more slides here. So let me go ahead and bring up my PowerPoint. Just give me 1 second here. Okay, so moving back to the PowerPoint here, one thing I do want to note is that as judges designees, you all have read-only access to submitted worksheets. So let's say you submitted the worksheet but forgot to print it out. Maybe before you submitted it, if you go back to the home screen here and check this box that says include submitted worksheets, that's under the worksheet ID field, and then, search using any of the various search features, you can confirm a worksheet has been submitted by looking to this submitted column on the right-hand side. If it has been submitted, you'll see a little check mark there. You'll also see this little Adobe icon, which means you can view the submitted worksheet. So again, you can't make edits to it. Only our commission staff can do that, but you do have read-only access to submitted worksheets. So that could be a helpful tool for you if you're not certain if you did submit a worksheet and want to confirm. So I wanted to point that out. And then just wrapping up the distribution of the completed worksheet. So this protocol for distributing the completed worksheet, it may vary slightly in each jurisdiction. We really encourage courts to establish whatever process works best for them. But in general, judges' designee should be printing a PDF of the completed worksheet, asking the judge to sign it, and then either providing a copy to the clerk's office for distribution, perhaps uploading that worksheet to MDEC. Again, it's really whatever process is currently in place for your individual jurisdiction. All right, so I just want to wrap up by highlighting a few of our commission resources. So our main website here, the www.msccsp.org, it's continually updated throughout the year. It's a really useful resource for any individuals who implement or utilize the sentencing guidelines. I mentioned earlier, our website also includes annual reports that are a great source to learn about the most recent sentencing trends and the work of the Sentencing Commission. Also, just want to highlight our guidelines e-news. We release probably 3 to 4 guidelines e-news throughout the year, and they help to inform about any changes to the guidelines. So if you don't currently subscribe to our e-news, if you'd like to be added, you can do so directly from our website. If you go to the main website in the lower right-hand corner, there's a spot for you to enter your contact information, or you can email us, and I'm happy to add you to our listserv there. More recently, we started producing a series of topical mini reports that we title Sentencing Snapshots that provide a quick review of sentencing trends and other topics of interest. So this most recent one was in August of 2023, and it highlighted sentencing trends in Maryland circuit courts for child abuse. If you subscribe to our e-news, you will automatically get our sentencing snapshots, but if you would like to check those out, they are also available on our website. PDFs of our guidelines manual and guidelines offense table can be accessed. You can also log into MAGS or access the guidelines calculator tool from our website. We have various instructional videos and guidelines webbing training webinars. If you go to our training page, you can access them then. There you can see here we have our recent webinar recordings. Any upcoming guidelines trainings will also be advertised on this training page. And then we also have a YouTube channel. So if you just go to YouTube and simply type in MSCCSP, you'll see all of our various training videos on our YouTube channel. We also have a crimes of violence data dashboard that can be accessed via our main website, our help desk 301-403-4165, as well as our general email, msccsp@umd.edu. If you've called or emailed us, you've probably spoken with me. I'm usually the first point of contact for the commission. So please, if you ever have questions about entering sentence information in MAGS or just general guidelines questions, please always feel free to reach out to us. We are always happy to help. So with that, I'm just going to check in with my colleague Sarah real quick to see if there's anything that we should address before we hop off.
Hi, Catherine. No, we don't have any outstanding questions right now. Give me 1 second. One just came in. Oh, so this is a good question. What if the defendant had their sentence is time served and it exceeds the total sentence? How would you input that into MAGS?
Yes, so sometimes this will happen sometimes. There are 2 different ways to go about entering that type of sentence. One, the statutory maximum, the credit for time served could actually exceed the statutory maximum in that particular scenario. So if that's the case, MAGS is not going to allow you to enter a total sentence that exceeds the statutory maximum. So you would essentially need to enter whatever that total sentence is. and then cap the credit for time served at the total sentence, which is probably going to be like the statutory maximum in that scenario. And then when you get to the GLS overall sentence tab, that's where you can explain and clarify that the actual amount of credit for time served is X amount. Alternatively, if the total sentence imposed still falls below the statutory maximum, I would recommend confirming with the judge whether to reflect the total sentence as whatever that total amount of credit for time served is. Or again, if the credit still exceeds that total sentence, you would just have to cap the credit at whatever that total sentence is. So hopefully that made sense. If you ever have a question about that, just feel free to contact us and I'm happy to tell you what value to enter in order to get everything saved correctly. And then we do have a couple minutes, so I'll just open this up if anyone wants to like unmute themselves. If you just want to quickly ask a question, I'll just give you all a second to do so. Okay, no pressure. Okay, so I think that wraps everything up. Again, ever have questions, please feel free to contact us. And thank you all for taking the time this afternoon to attend this training. I know it was a lot, but I hope you found it to be informative and helpful. And with that, have a great rest of your day and a great weekend. Thanks all.